lots of paper, legal and physical issues. In this part, peruse the many different legal issues connected with the sale or purchase of a property, including some basics about the type of contracts you're likely to use, how a contract is discharged, and what happens when the terms of the contract aren't complete. Examine how a contract is created and executed, and the important role real estate agents play in this process. Understand the requirements of a physical lease agreement, the different type of leases, and in some ways, people break leases. You may never handily lease property, but the exam requirements that you have a basic understanding of lease. Expand your knowledge with information about some of the environmental issues and government regulations involved in real estate work, as well as environmental effects of developing property from wastewater. In this chapter, checking out the basics of contracts, looking at different kinds of real estate contracts, discovering various ways of ending contracts, finding out what makes someone break a contract. Chapter 11, Contracts 101. When you agree to represent a buyer or seller as an agent, you and your client sign a contract for your services. After that, your hard work brings the buyer and seller together to sign the contract of sale. I said signs and brings, not might sign or could bring, because I know you're going to be a great successful as a real estate agent. A lease also is a contract. In a real estate business, you deal with people and other kinds of contractual agreements. Negotiating, understanding, and in some cases preparing contracts are important parts of your job as a real estate agent. State exam writers expect you to have some knowledge of contracts in general and special knowledge about different types of real estate contracts. In this chapter, I'll walk you through some basic information about contracts, including elements that make the contracts valid. I'll also tell you about specific types of real estate contracts and give you some information about how a contract is discharged and what happens when a term of contract is not completed. Agreeing to do something, the basics of a contract. People agree to do things all the time. I agree to pay the bill in the restaurant. Someone else agrees to pay the kids to shovel the snow off the driveway. You agree to represent someone as an agent. And of course, a buyer agrees to buy a seller's house. All these agreements are contracts. A contract is an agreement either to do or not to do something. The agreement must be made voluntarily and legally competent parties. Have some form of legal payment consideration as part of the agreement, and be about doing or not doing some legitimate act, and to be enforceable. In this section, I tell you about different ways that contracts can be created and give information on the elements of a valid contract. Although this section is about contracts in general, rather than real estate contracts in particular, remember that the real estate exam writers like to know that you know at least some of the basic information about contracts. Exploring how a contract is created. A contract can be created in a number of ways, which is usually are defined by the actions of each party to the contract. The contract may fit into more than one of the following categories. Pay particular attention to the contract examples in this list that follows, so that you can distinguish among the different ways a contract may be created. There are unusual, at least a few questions on exam that require you to distinguish among the different types of contracts. An express contract is created when parties to the contract, the participants, clearly state in words what they agree to do and not to do. The parties clearly express an intention. An express contract may be either oral or in writing. Mr. Buyer agrees in writing to buy Mrs. Seller's house for $300,000. Mrs. Seller agrees to sell for the amount. This is an express written contract. Real estate sales contract and usual lease for a period over a year must be in writing to be valid. On the other hand, you agree to represent a couple as an agent to sell their house, and they agree to pay you a percentage of the sale price when you sell the property. You have no written document of this arrangement, only your oral agreement. Foolish. Probably, after all, the money on the line. In some states, you don't allow you to enforce an oral listing agreement when trying to collect fees, but the legal nonetheless. You're an express oral contract to act as the seller's agent. Implied contracts are created by the actions of the parties. A classic example of an implied contract is someone who goes into a restaurant and orders a meal. The person never says to the server, "If you bring me a steak, I'll pay you," and they'll say that on the menu. The fact is that the person agreeing to pay the bill for the meal is implied. In real estate work, an agent brings a buyer to see a house that the owner is selling may create an implied contract. No agreement exists, but agents ambitious enough nonetheless brings a buyer to the house. The seller lets the agent show the house, and the agent takes up upon himself to negotiate the deal on behalf of the seller. A seller lets her. Eventually, a deal is made. The agent expects a commission from the seller by virtue of the fact that the agent brought together the buyer and the seller, and both the buyer and the seller let her. Nothing in writing, but the actions of someone's concerned may be created in an implied contract. A bilateral contract is one of which two parties agree to do something, in effect exchanging promises. For instance, I, the buyer, agree to buy the house for $300,000, and you, the seller, agree to accept my $300,000 and give me title to your house. This agreement is an express, and promises are stated bilateral. Both parties agree. Contract typical of real estate sales contracts. In a bilateral contract, each party can force the other to act. So I can force you to sell me your house, even if you become unwilling to do so, as long as I'm willing to pay you what I promised. A bilateral contract may be expressed, as in the case of the sales of the contract, or implied, as in the case of a tenant who has no lease and a landlord who keeps collecting the rent. Their actions imply an agreement that each can enforce. A unilateral contract is a one-sided agreement in which only one party, Party A, for the sake of example, is obligated to do what is promised. The obligation exists only to the other party, B, does what is stated on the contract. Party B, in this case, is free to do what is stated in the contract. An example of a unilateral agreement in real estate is the option agreement. In this example, the seller agrees to not sell the property for a year while the buyer attempts to get financing and other approvals, such as building permits. The seller further agrees to sell the property within a year time to the buyer for $1 million if the buyer wants to buy it. The word is "if" is key here. The buyer is free to buy or not to buy, but the seller must sell the property to the buyer at the stated price if the buyer wants to buy within the same year. The buyer is exercising the option. All the states have passed some version of laws called the Statute of Frauds. The Statute of Frauds generally requires most real estate contracts to be in writing for them to be enforceable. You need to check out your state-specific real estate exemptions to the Statute of Frauds requirements for written real estate contracts. For example, at least one state exempts lease contracts or lease or less than a year from having to be in writing. Most states also have adopted some of the Uniform Commercial Code (UCC), which governs sales and contracts involving personal property like a car. For a sale of a personal property to be enforceable, it must comply with the rules adopted by the state. A typical UCC rule is that the sale of personal property more than $500 must be in writing. Although questions about the specific rules of a UCC probably won't be on exam, you may nevertheless see a general question related to it. Cooperative apartments are considered personal property, so their sale is governed by part of the UCC. Check out your states and those portions of the UCC that deal with the real estate issues. What makes a contract valid? For a contract to be valid, binding on all parties and legally enforced, it must contain elements. Stated exam writers expect you to have an understanding of the following 5 elements that must be present for a valid contract to exist. Legally competent parties. For a contract to be valid, people making an agreement must be of legal age and in the state in which the contract is executed. They must be sober, sane, and mentally competent to enter into an agreement. Parties to the contract need to be acting freely and voluntarily and under no undue influence or duress. Mutual agreement. sometimes referred to as mutual assent, mutual consent, and meeting of the minds or offer and acceptance. Mutual agreements means that the terms of the contract must be clearly understood by all parties, who must also agree with and understand what they're agreeing to. Find out whether your state has any kind of law that requires contracts to be written in easily understandable language. These are commonly known as plain language laws. Check out Going Back and Forth with Offer and Acceptance later in this chapter. Lawful object, sometimes referred to as legality of object, or lawful object. Lawful object means that what you're agreeing to is in fact legal. In the movies, the classic mob contract to kill someone is not a valid contract because the object of the contract is illegal. Consideration. Consideration is usually some clear stated item of value that is exchanged for the promise made in the contract by the other party. The thing of value doesn't need to be money. It can be a promise to do or not to do something. In the case of a real estate transaction, it can be an exchange of one piece of property for another. You should remember that a real estate sales contract, the consideration is the agreed to sell price. Agreement in writing. The agreement in writing rule applies to certain kinds of contracts, including most real estate contracts are required to by state in particular statute or frauds. See Exploring How Contracts is Created earlier in this chapter. Likewise, be sure to check out how the parole evidence rules relates to oral contracts. Under certain circumstances, the parole evidence rule enables oral agreements to complete or clarify unclear written agreements, but it also presumes that in most cases written agreements are more valid than the oral agreement and more clearly stated the intent of the parties. Here's an example. You contract to have a house built, and the contract says you're going to get model A23 doorknobs. Later, the builder agrees to install the more expensive model B34 doorknobs at no additional cost. At the end of the project, he installs the model A23 doorknobs and attempt to get the better doorknobs by taking the builder to court. The courts may presume that the written contract is more valid, indicating of what you agreed to, and dismiss your case. On the other hand, if no doorknobs were specified, the court may view that the oral agreement as in the completion of specification of the contract, and you may get the doorknobs you want. A void contract is one in which one or more of the required elements is missing. A contract to do something illegal is a void contract. A void contract, because it is missing one or more key elements, never really existed as a contract in the first place. A couple of gray areas that the world of valid versus valid contracts, voided contracts, do exist though. A voidable contract usually involves a situation where one of the parties may not have the legal ability to enter into the contract, but may confirm the contract at a later date and time. Suppose a minor who is younger than the legal age of entering into a contract signs an agreement to buy a house. The minor can neither declare the agreement void within a reasonable time to reach the case with avoidable contracts. One party, in the instance is the minor, can get out of the contract, but the other party is obligated to adhere to the agreement. If the contracts were completely void, then neither party would have to act. The law generally views the example as a valid contract unless the minor decides to get out of it. The unenforceable contract is one that seems valid and may, in fact, have all the elements of a valid contract, but for one reason or another, it can't be enforced by one party against another. Here's an example. You have a house custom built for you, and you believe that the builder didn't build the house according to the contract you signed. You sue the builder, but because the statute of limitation, the time set by law in which you can sue somebody, has run its course for such lawsuit, you can't enforce the contract against the builder. The contract is unenforceable. However, the builder can choose to honor his obligation and make good on his contract, a situation that is described in the contract being valid as between the parties. The word enforceable means that the courts can, within an existing law, make the parties to the contract do what they agreed to do. In this example, the courts can't enforce the contract because the laws set a time limit for enforcement has run out. Two more words that are used to describe the contract are exclusionary and executed. Exclusionary contracts is one in which one or more of the terms of the contract have not been completed. The executed contract is one in which everything is completed. For instance, after a real estate sale contract is signed, it's considered exclusionary. After the word ownership passes from seller to buyer at the closing, the contract has become executed. So many choices. Examining types of real estate contracts. A number of different types of contracts are used in real estate business. State exam writers expect you to understand what those contracts are and how they work. Finding out about agency agreements. I cover seller and buyer agency agreements in detail in Chapter 4, but you need to know a few specific details about agency agreements. Just remember that the agency agreement signed by a real estate agent and a client enables the agent as a representative of the client. Listing agreement. A listing agreement is between the agent and a property seller. Note that to use the word agent here, I'm using it in the sense of the person whose listing it is. And in all cases, it will be a principal broker. A salesperson working for the broker may be responsible for the listing, and it may be referred to as a salesperson listing, but the fact the agent and the seller is hiring is the principal broker. The following are a few common listing agreements. The exclusive right to sell listing agreements requires the compensation to be paid to the broker regardless of who sells the property. The broker of the property owner. This agreement is a bilateral contract between both parties, exchanged for promises that can be enforced to act. The agreement can be forced to do his duty, and the seller can be forced to pay a commission. This type of listing agreement generally requires specific promises from both parties. It is also considered an express contract, which means the promises have been spoken and agreed to, or more likely have been put in writing. The exclusive agency agreement is one in which a fee is owed to the broker only if the broker sells the property. If the owner sells the property and the owner is owed nothing, this contract is unilateral because nothing was owed unless the broker produces a buyer. This type of listing agreement becomes bilateral agreement when and if the broker produces a buyer because at one point both parties have been obligated that must be fulfilled and can't be enforced. This type of agreement is usually expressed because the listing agreement contains the details to which both parties agree. In an open listing agreement, an owner agrees to pay a fee to any broker producing a successful buyer. An open listing is unilateral contract because only one party, the seller, is obligated to act if and when an agent produces a buyer. When listings can be expressed, if, for example, a seller advertises his home for sale and the advertisement states that he will work with the brokers. Buyer agency agreements. Buyer agency agreements are formed between the agent and someone who wants to purchase a property. The exclusive buyer agency agreement requires that the buyer pays the agent whether or not the agent finds the buyer the house that the purchaser buys. So if the buyer locates a property on his own and buys directly from the seller using no agent at all, the buyer still owes the agent a fee. This agreement is bilateral in that two parties exchange promises and expressed because its promises are stated. With an exclusive buyer agency agreement, the buyer is obligated to pay the agent only if the agent produces a property that the buyer buys. It's a unilateral agreement because nothing is owed unless the buyer agrees to produce a property for the buyer. It is usually expressed because the promises made are stated and usually in writing. In an open buyer agency agreement, the buyer essentially says he will pay any agent who finds him a property. It is a unilateral agreement because only one party is obligated to act, and it may be expressed if agents are notified in some way that the buyer is looking for a property and willing to pay an agent who finds one for him. Examining sales contracts. Real estate sales contracts indicated a buyer and a seller agreement and exchange property for usual money. I discussed the elements necessary to make the sales agreement valid and enforceable. A sales contract is a bilateral, two people exchanging promises express. Each party states what they're agreeing to agreement. Making a sales contract valid and knowing who prepares it. For a real estate sales contract to be valid, it must be complied with the law of the state where the property is located. Although many may vary slightly in states, the following elements generally are the minimum requirements. Legally competent parties, a contract that must be in writing, a legal description of the property, words of mutual agreements to buy and sell the property, consideration or what is being paid or exchanged, and any other financial terms. Signatures of both parties, of all parties. The signing of the contract for the sale of the property gives the buyer equitable title, which isn't yet ownership and which can be conveyed only by a deed. Instead, the contract rights essentially gives the buyer the right to demand title, ownership to the property when the agreed upon price is paid. Lawful object. This requirement is usually pretty easy to meet because the object of the real estate sales contract is to sell real estate. For exam purposes, you should remember that the elements for a valid contract are that each of these items mean based on the list and the definitions I provide above. A direct question about who prepares the sales contract isn't necessarily one you'll find on exam, but you nevertheless need to check out your state's approach. Typical alternatives for testing you on documentation are situations in which preparation of the sales contract is done by a real estate agent, by an attorney, or by an agent subject to review by an attorney. Agents who prepare their own sales contract often use a pre-printed fill-in-the-blank contract form. An additional piece of information that you need to check out is what, if any, roles attorneys play in selling a piece of property in your state, a factor that varies widely throughout the United States. In no case can someone who is not an attorney practice law. In most cases, brokers protect themselves against the charge of illegally practicing law in these circumstances by stating on the form that the signer needs to consult with an attorney before signing the form, or the validity of the form is contingent on the attorney's approval. Adding extras to sale contract. In addition to the necessary items required for a valid contract, many sales contracts contain information about the type of deeds that will be delivered to the buyer, and encumbrances of the title, and any money being deposited as part of the agreement. A statement of the constituents evidence of any money being deposited as part of the agreement. A statement that would constitute evidence of good title. A date and place of closing, and what happens in the event of the destruction of the property before the closing. In other terms, the conditions of sales. See Chapter 9 for more about deeds and other closing, and Chapter 8 for the scope of encumbrances. You need to check out what, if any, law exists in your state with respect to the consequences of destruction of the property. In many states, unless the contract says differently, the buyer bears the responsibility for the loss if it results to the destruction of the property. States that have adopted Uniform Vendor and Purchase Risk Act requires the seller to bear any loss that occurs before the title is passed to the buyer. The element that typically appears in a sales contract is contingency clause, or a statement that requires specified conditions or conditions must be met for the contract to be completed. Typical conditions in a real estate sales contract are the mortgage or the finance contingency and an inspection contingency. The mortgage contingency allows for the possibility that the buyer may not be able to afford to buy the house. Upon agreeing to purchase a house for $200,000 and coughing up $25,000 in cash for the down payment, the buyer plans to borrow the rest through a mortgage loan. Because the sale can't go through unless the buyer can borrow the full $175,000, the buyer puts a clause in the contract that enables him or her the option of getting out of the deal if the lender refuses to approve an adequate mortgage amount. Without the mortgage contingency in the contract of sale, the buyer can lose the down payment if the purchase doesn't go through as planned. An inspection contingency, on the other hand, is an agreement that requires an inspection or an inspections of the house by the home inspector. The house must pass the inspection. If a contingency clause is included in the contract, the buyer can get out of the deal if the inspector finds something wrong with the house and the seller refuses to repair it. A third contingency that you may see is one in which the buyer must be permitted to sell his concurrent home before being forced to buy the new home. The contingency protects the buyer from owning and having to pay mortgages on two homes at the same time. Going back and forth with offers and acceptance. Because real estate deals often are a result of a process of negotiations, you need to understand a few of the concepts of the offer and acceptance process. Generally, this process is negotiating following the patterns of the sellers listing in the house for sale, the buyer making an offer to buy the house, and the seller's counteroffer, and acceptance by the seller with as many counteroffers proposed between the offers and acceptance are needed for the two parties to come to a meeting of the minds, which is also called mutual assent. An exam question on the offer and acceptance process may present a case, although called mutual assent. Exam questions on the offer and acceptance process may present a case of a buyer and a seller going back and forth and asking you if the particular offer is binding. Remember that as soon as the seller counteroffers to the buyer offers no longer exist. Suppose that a list of houses for sale for $250,000. You offer to buy the house from me for $200,000. I counteroffer that I'll sell you the property to you for $240,000. You tell me you agree to the price. That's acceptance. For the process to lead to the meeting of the minds, the two parties must agree to all the terms and conditions of the contract sale. For example, because it's a high real estate market, I advertise my house for sale for $250,000 and say that I want no mortgage contingencies in the contract. You agree to pay $250,000 but want a mortgage contingency in your contract. Your offer stands until I accept or reject it. If I stick to my original conditions, I counteroffer and tell you I'll accept your price but not the mortgage contingency. And when an offer or counteroffer is rejected, its case to exist. It ceases to exist. And previous offer and counteroffers cease to exist. Here's another one for you. You list your home for $250,000. I offer you $180,000. You don't think I'm really serious, but you're willing to try to negotiate. You counteroffer $230,000, but I respond with a counteroffer of $185,000. At that point, you get annoyed and issue a counteroffer back up to $250,000. After our counteroffer is $185,000, you effectively refuse my offer and it disappears. It was if you were stating negotiations from scratch. So I can counteroffer anything I like. A binder or offer to purchase may be the first step towards solidifying a deal in some parts of the country. The different parts of the same state and in recent years among different brokers in the same market area. A binder is usually for residential real estate. Similar agreements called the letter of intent is used in commercial real estate transactions. A binder is used primarily to signify that a deal has been made and an agreement has been reached to go forward with one formal contract negotiations. At that point at which there is an acceptance offer, both buyers and sellers sign the binder. A binder often is accomplished by an earnest money deposit or down payment to signal the buyer's seriousness in going forward with the purchase. In other parts of the country, binders are not used, but sales contracts is prepared immediately. Discovering options. An option in real estate terms is the agreement that the seller agrees to sell property to the buyer at an agreed to price within a certain time frame if the buyer wants to buy it. The seller may not sell to anyone else during the option period. Unlike a regular real estate sales contract, the buyer doesn't have to buy the property. But if the buyer wants to buy, the seller must sell. Only one party, the seller, has to act. The buyer has the option of buying or not buying. Options on express unilateral contracts. A real estate purchase option works like this. You're selling your property for $500,000. I want to buy it, but maybe I want to find out from a local government what I should build on the property, and doing so will take some time. You agree to take the property off the market and give me an option to purchase the property at $500,000 within 1 year. I'll pay you something for the option, and you may or may not be credited towards the purchase price, depending on the terms of the agreement. The option gives me the right, but doesn't obligate me to buy the property for $500,000 within 1 year. If I choose to exercise the option, you must sell me the property. If I choose not to exercise it, you can't force me to buy the property. In addition, the basic elements of the valid contract, which you can find earlier in the chapter, the option normally has a time limit attached to it, and unlike that, an option would run forever. Looking at land contracts. A land contract, which may also be known as installment contract, conditional sales contract, contract for deed, and the land sales contract, may be used to purchase property without immediately paying the full price and without obtaining a mortgage. What happens is the buyer or venue pays the seller and vendor so much money down, it pays the vendor a little at a time, usually in monthly payments over a period of time over a year until the property is paid off. The buyer receives equitable title, the right to force the seller to give the buyer a full title when the term of the contract has been fulfilled to the property, but the seller retains full title, complete ownership of the property. The buyer can use the property and must pay all the bills on the property, but he or she does not receive a deed of ownership of the property until a certain number of payments are made to the seller. See Chapter 9 for more about deeds. A land contract generally is a bilateral express contract because the two parties are required to act and the promises are expressly made to each other. For the exam, remember that if you see the word vendor or vendee, the question will likely be about land contracts. Checking out lease. A lease is a form of real estate contract that gives someone exclusive use of a property for a period of time for a fee. Leases contain all the elements of a valid contract. I'll talk about leases in details in Chapter 12. The end of the line. Discharging a contract. Discharging a contract means ending the contract in one of the several appropriate ways. Test questions on this topic tend to focus on the definition of the different ways of ending contracts. The most common and the best way for a contract to be discharged is by performance, so I'll list that first, but I also list the others here in alphabetical order. Performance. Performance is the ideal way of ending a contract because all parties have fulfilled their obligations. Time is of the essence, and in the phase that something is used in a contract to mean that a breach of contract occurs if an obligation isn't completed within the specified time frame stated in the contract. For more on breaches, see the next section. Assessment and delegation. Someone is taking over or is assigned the obligation of one of the parties to the contract. The parties taking over the obligation is called the assignee. Say, for example, that a builder who agrees to build you a house for some reason can't afford to do the job, but I assign a contract to another builder who builds you a house under the same terms and conditions that you and I agree to. The example is different from delegation, where you'll simply hire another builder to work for me to build you a house. In an assignment, my responsibilities and obligations are transferred. In a delegation, I remain primarily responsible. Death. If you die, you definitely don't have to fulfill your obligations under the contract. However, that doesn't mean that someone else won't have to do what you agree to do. For example, your estate may be required to go ahead and purchase a property that you contracted to buy before your death. Impossibility of performance. In a situation where the actions that was contracted can't be performed legally, its possibility of performing the task can be declared impossible. For example, suppose you hire a builder to build an addition onto your house, and after you sign the contract, you find out the town won't let you build the addition. At that point, you have no longer obligated to do so with the contract because the performance is legally impossible. Mutual agreements. In a situation both parties to the contract agree to cancel it, they can agree with no penalty to either party, or they agree with some exchange for money to pay for any damages or losses to one or the other parties. Notification. Notification is a situation in which a new contract with different terms replaces the old one. A new contract can be between the same parties or between one of the parties to the original contract and a new party. Writing a new contract when only a minor change needed to be made is not a usual course of action. Each party usually just initials the date and minor changes to specify their acceptance. Notification is reserved for major and more severe changes. Operation of law. The type of situation can be related to some legal issues that arises and creates and cancels the contract. For an example, a contract that is made on the basis of fraud is canceled when the fraud is discovered. Partial performance. Discharging a contract for partial performance refers to acceptance by one of the party in incomplete work by the other party, an agreement that the incomplete work will constitute fulfillment of the terms of the contract. Rescission. A rescission of a contract sometimes is called a unilateral rescission. Don't you wish these people could come up with the normal names for this stuff? Anyways, rescission is when one party decides not to fulfill its obligation under the contract and considers the situation to be as if the contract never existed. One party to the contract sometimes uses rescission when the other party doesn't appear to be fulfilling its obligation. For example, the painter who never showed up to paint your house may point to you to rescind the contract. Substantial performance. With the work under contract nearly completed, substantial performance discharge of the contract may be in order. Under these circumstances, one party may force payment for the other party. Say, for example, a contract to build an addition onto your house, and the builder finishes 95% of the work, but you still owe him a third of the agreed upon amount for the project and refuses to pay until the last 5% of the work is complete. The builder can sue you for payment on the basis of substantial performance, and the courts may let you keep a small amount of the money, not the 33% you're holding, to finish the job. The builder receives most of the payment and is obligated to you or declared over. Breaching a real estate contract. Sometimes people simply don't do what they're promised to do, even after they sign the contract. These situations are the kind in which one of the parties, but not the other party, refuses to do what he or she has promised in the contract to do. A number of remedies and actions can be taken when a breach of contract occurs. I discussed these remedies from the buyer's side and from the seller's side. For remedies related to the tenancies and landlord and lease, see Chapter 12. State exam writers expect you to know these different remedies and to be able to identify them in the question. When a buyer refuses to go ahead with the contract, when a buyer defaults and refuses to buy the house that he signed the contract to buy, even though the seller wants to go ahead with the sale, here's what the seller can do. Forfeit the contract. In this case, the seller formally declares the contract forfeit. The seller typically is entitled to keep whatever money the buyer already has put into the deal. A liquidated damages provision in the contract deals with this. Rescind the contract. After the buyer defaults, the seller declares that the contract rescinded. This statement puts everyone back in the same position as when the contract never existed. Suppose the seller receives a higher offer a few days after signing the contract of sale. The buyer's money is returned and the seller rescinds the contract. Full suit for compensation Compensatory damages. The seller brings a lawsuit against the buyer for the monetary damages that the seller believes has been experienced because the buyer default on the contract. An example is when the seller sues the buyer because he lost a deposit on a house that he was going to buy. The deposit was paid only after he had signed the contract to sell his own house. After suit, his specific performance. The pursuit of this kind of lawsuit, which the seller brings against the buyer, is to force the buyer to buy the house. The buyer's market, one in which there is more sellers than buyers and housing are selling slowly. The seller may use this remedy whenever finding another buyer is going to be difficult. When the seller refuses to go ahead with the contract, the seller defaults. Even though the buyer is prepared to go ahead with the deal, the seller refuses to sell the house. Here are the remedies at the buyer's disposal. Rescinding the contract. The buyer can rescind the contract and basically let the seller off the hook. The buyer's money is returned and the contract does no longer exist. File suit for compensatory damages. In this case, the buyer sues the seller for monetary damages because the buyer believes that she has suffered because of the seller's default. For example, a buyer-seller for the house is living in a rented apartment for her furniture and storage because she signed the contract to buy another house, but the seller defaulted, and the buyer can sue the seller for the cost of the rented storage spaces that she has to pay while looking for another house. File suit for specific performance. This type of lawsuit is designed to force the seller to go ahead with the sale. Even the fact that no two properties are exactly alike, this remedy can be pursued when monetary damages won't satisfy the buyer. The buyer really wants the particular house. And that was part 4. A house is made up of a lot of paper. Legal and physical issues. Chapter 11. Contracts 101.